Namaskar. Welcome to another episode of Editorial. The Supreme Court today said that, listen, you could be an MLA, MP, whatever you could, but there is no immunity from bribery. You can't take money, you can't take bribe and say, you're immune. Sounds strange, na? Let's discuss this case threadbare. Let's get right into the show. In a landmark judgment, a 7-member bench, Supreme Court bench, including the Chief Justice of India, and I will name all the judges, this 7-member bench said that, listen, you know what? Bribery ke liye, there is no immunity. Whether you are in the house, you are not in the house, there is no immunity for no MLAs, for no MPs. Which means for voting for a particular political party, if you take bribe, or for speaking something, if you take bribe, you don't get immunity. Now, a lot of us may ask, ye kya hai? I mean, you mean that MPs and MLAs had immunity if they take bribe and they vote for any party they want? Did they have that kind of immunity? The actual answer is yes, they did. And let's try and understand this entire concept very clearly. That is what I will try and do through my editorial. Okay, let's go right from the beginning and then let's come back to where we started from. You see, in 1993, when PV Narasimha Rao was the Prime Minister, PV Narasimha Rao was falling short of 14 members because there was a no confidence motion against him and he was falling short of 14 votes. For these 14 votes, it is said that PV Narasimha Rao and his people bribed 14 MPs. And that's what the charge sheet of CBI and all claims. He bribed 14 MPs. And finally, he won. He won because for the no confidence, on 28th of July 1993, for the no confidence was 251 seats. And against the no confidence motion was 265 seats. So 265 seats was in his favor. So he won and won with 14 seats that CBI claims that he had paid bribe to. Now, this is the case that one is referring. And at that point in time, the case had gone to the Supreme Court, and Supreme Court, 1998, in a majority judgment, 5-member bench, wherein the majority judgment, because 3:2 was the judgment, 3 people was for and 2 people were against. In a majority judgment, the judges then felt that no, the people who took bribe should be given immunity under the Article 105(2) of the Constitution and 194(2) of the Constitution. So under, like I told you, 105, 192(2), they were given immunity. They were not arrested. ठीक है ना? This is what happened in 1993, decision 1998. Today we are in 2024. 2024, the 7-member judge, now let me tell you who were the 7-member judge. The 7-member judge was headed by D.Y. Chandrachud, Chief Justice of India, Justice A.S. Bopanna, Justice M.M. Sundresh, Justice P.M. Narasimha, Justice J.B. Pardiwala, Justice Sanjay Kumar, and Justice Manoj Misra. A 7-member panel of judges, they said nothing doing, we are overruling the 1998 majority judgment. They said, and I will quote them, that we disagree with and overrule the judgment of the majority on this aspect. We have concluded that first, the doctrine of stare decisis is not an inflexible rule of law. A larger bench of this court may reconsider a previous decision in an appropriate cases, bearing in mind the test which have been formulated by this court. The judgment in PV Narasimha Rao, which grants immunity from prosecution to a member of a legislature who has allegedly engaged in bribery for casting a vote or making a speech, has wide ramification of public interest, probity in public life, and parliament democracy. There is a grave danger of this court allowing the error to be perpetuated if the decision were not reconsidered. So, the 7-member panel of Supreme Court said that, Baba, listen, you can't just take money and vote for a particular party or not vote for a particular party or speak something because you have taken some money. I mean, the judges then must have thought of whatever they thought of at that point in time. That is fine. But you can't just take money and then decide that, I'm going to vote for this party or not vote for this party or speak what I want to speak. So that's not possible. So the judges said that, listen, there is a larger ramification to this country. ठीक है. Now let us understand कि भाई ये क्या है? ये what is this 109 and what is this 154 and all that? Let's first understand that and let's get into more details. You see, 105, Article 105 deals with powers, privileges of the Houses of Parliament and of the members and committee thereof, subject to the provision of this constitution and to the rules of the standing orders regulated procedure of parliament. There shall be freedom of speech in the parliament. So, Article 105 is meant for houses of parliament. Houses of parliament, which means MPs, Rajya Sabha and Lok Sabha. Article 194 guarantees freedom of speech to the members of the state legislature, mane assembly, and grants them immunities provided from time to time under the law. Further, it protects MLAs from being tried for their speech or vote in the legislature. ठीक है. Both of them. So, Article 105 for the houses, that is Rajya Sabha and Lok Sabha, and 194 for assembly, the state legislature. ठीक है ना? More or less the same. Now, what does this law say? This law says that, Baba, listen, you know what? You are representing the people, na? You are representing the people, so you have the right to speak. You have the right to put up, state what your constituency needs. You have the right. Even if that goes against, or even if there could be allegations against you, even if this could go against some law, if the constituency needs something, you have the right to speak for your constituency without any fear of being prosecuted. That's broadly what this law means. This law also says that you can vote for whichever party you want because that helps your constituency. That helps the people of your constituency. So you can vote without fear, without being feared of being prosecuted and all that. You can vote without fear. That is the basis of this Article 105 and Article 194. कि भैया constituency के लिए for your people you can take the right steps, you can take the right decision without being scared or being prosecuted. ठीक है ना? Now 1052, let me get into specific as to what this particular law talks about. Article 1052 confers on the member of parliament immunity from prosecution in respect of anything said or any vote given by them in parliament or any parliamentary committee. Grants similar, 194 also grants similar proposition to MLAs. So what does this 1052 and 1942 article says? They say that we give you immunity. We give you immunity for any vote casted or any speech made by you in the parliament. Parliament and legislature, like I told you, 105 for the parliament and 194 for legislature. Okay, now there is one more thing to this, and that is if supposing the person, the MP, the MLA takes bribe and the person does not vote for that particular party from whom he allegedly took the bribe, he or she allegedly took the bribe, then by omission in this verdict of 1998, he can be prosecuted. मतलब end of the day क्या है कि bribe लिया and you voted, it's all fine, you're immune. Bribe लिया, you don't vote for that person, then you can be prosecuted. That's how this verdict looks. Now, let me also in the same breath say, you see, the reason why this verdict was written is not because to encourage bribe or something. Let us be reasonable. That is not why those judges wrote this verdict. Yes, this omission is very glaring. So I think we've fairly understood the law, and fairly, I think we also understood why that decision could have been taken then when the decision was taken. But of course, any privileges, any rights, any immunity given to our honorable representatives, public representatives, are most often than not misused. This too was misused. And the honorable judges from Supreme Court, they completely threw this out of the window and they said no immunity from now on. No immunity from now on. So this is what the case is. This is how it all went. Now let me tell you, our Prime Minister, Narendra Modi, he tweeted today saying that Swagatam, a great judgment by the Honorable Supreme Court which ensures clean politics and deepens faith in the system. And I too feel that it is a good judgment because yes, why should MP and an MLA get immunity for taking money and voting? Achha, all this is fine, but I have a couple of questions. In the interest of fairness, I have a couple of questions. While the Prime Minister said Swagatam, it's a great judgment, I want to ask, you see, who actually investigates and finds out whether a person has taken money to vote or not taken money to vote? It is the CBI or it is the ED, right? These organizations that actually investigates and find out. Now tell me, are the CBI and ED independent? Do they go and do proper investigation and say that, listen, if the ruling party man has also taken money, we will pay, we will catch you. And if the opposition has voted for the ruling party by taking money, he will still catch you. Make the charge sheet and produce it in front of the court. Is that going to happen? Will that really happen? Has the Honorable Supreme Court ensured those riders are also in place? So that's my first thing. So it is the CBI, it is the investigating bodies that finally say that the person has taken bribe or not. But then how does one ensure that the investigating bodies, that the CBI, ED, etc., does it impartially? Number one. Number two. Achha, what happens when you have anti-defection law, you have other laws which are made actually fun of, which are mocked at? Anti-defection law every second, including Maharashtra, the state I sit in today. Like I always say, in our state we've got two NCPs, one NCP sitting in the opposition, one NCP sitting in the government. We've got one Shiv Sena sitting in the opposition, one Shiv Sena sitting in the treasury bench. So in a state like ours, for instance, where governments were pulled out, MLAs ran away, they ran from one state to another, hid there, and then they came out, and then they formed a government. All this is happening. Isn't that equally sad like this case which we just mentioned? This is bad, of course, taking money for voting for a particular party, cross-voting, it's absolutely sad. No doubt about it. But isn't jumping from one party to another party also sad? Isn't pulling down a government by jumping from one party to another party also equally sad? Doesn't the same logic of Honorable Chief Justice of having larger ramification on the society, by jumping parties, by pulling down governments, doesn't it happen? Isn't that too something that is condemnable? Isn't that too punishable? Is there a law punishing this? Now that's something that I leave you to decide. I leave you to think. But that said, all said and done, this was a landmark decision. It was a good decision. And like the Prime Minister of India, I too say, Swagatam, what a good decision that the bench took. Till I see you next time. That's tomorrow at 10. Namaskar.
Stay ahead with our cutting-edge news app. Instantly access the latest shorts in just 1 minute and breaking news in just 50 words. Download now for a smarter, faster news experience.